Neither the parties, children, or any therapist were considered experts. None of the attorneys, guardians ad litem, child advocates, mediators, parental coordinators, custody conciliators, law enforcement officers, or CPS personnel were considered. Any type of speculation or uncertainty was excluded. Over the course of the research, the investigator of the study trained and supervised 6 assistants, all with experience with legal research, to carefully review each of the 3,555 cases. The team tallied each year from 1985 to 2018. Every case citation that fit that limited criteria, appointment of the independent expert, and/or a finding of parental alienation, was pasted into the tally sheet for the year in which it occurred. The others were excluded and considered not relevant. Of the cases that were relevant and included, the tally sheet measured the year, the gender, male, female, or non-determined, and the number of substantial changes in custody. Substantial change in custody was defined as a substantial difference in the parenting time allocation after the parties were in court versus before the parties were in court. The results of the analysis were as follows. Out of the 3,555 cases, 1,181 were considered relevant cases and met the strict inclusion criteria. Let's consider how a court decides if evidence of parental alienation is admissible. The court determines that expertise is needed and the witness is actually an expert, and what the expert is offering is material to the issues, meaning it has significant importance rather than just a trivial fact, and what the expert is offering is probative of a fact at issue, meaning evidence that tends to prove or disprove a point in issue, and it is relevant, meaning it has a tendency to make a fact more or less probable than it would be without the evidence. When all this criteria is met, then it's admissible. The courts found the issue of parental alienation to be admissible 1,181 times. 3 figures illustrate the results of these cases. Figure number 1 shows a consistent, steady increase in the number of reported parental alienation cases between 1985 and 2018. The upward trend indicates that the number has grown over the years, suggesting that courts and their participants have increased their awareness and/or reliance on parental alienation theory over time. Figure number 2 shows the proportion of cases each year involving female alienators, male alienators, or some other category of alienator. During 1985 and 2018, about 63% of the identified alienators were female and 23% were male. This proportion has remained approximately the same over the years. Figure number 3 shows the proportion of cases each year in which the court significantly changed child custody arrangements, such as transferring custody from one parent to the other or substantially changing the parenting time. Over the whole, a significant change occurred in 61% of the cases. The cases analyzed in this study demonstrate that experienced judges, litigators, and mental health professionals across the United States are increasingly recognizing parental alienation and its materiality, relevancy, and admissibility for determining child custody disputes. None of the cases documented a family court judge changing custody to a physically abusive parent. Together with the fact that at least 23% of the 1,181 cases returned in the search involved male alienators and female targets, this refutes the claim that parental alienation was no more than a litigation tactic fabricated by male perpetrators of intimate partner violence. Limitations of the study is that it underreports the scope of parental alienation. First, it only discusses reported cases, which are mostly appellate cases, and there are dozens more trials involving parental alienation that don't get reported or appealed because appeals are expensive. Second, the inclusion-exclusion criteria was purposely very restrictive to get a conservative, reliable number, and therefore the total numbers underreported. Third, there are other, less popular terms for parental alienation that the search query didn't pick up. Parental alienation is real. It's admissible in court. And when it's found to exist, it significantly impacts the custody arrangements to protect the relationship between children and parent. This study and presentation was written by Dr. and attorney Demosthenes Larandos of the law firm Psych Law, and the video was produced by the Law Center. Go to the description portion of this video to learn more.